Okay, this is just an overview of the law surrounding unfair dismissal in Ireland, brought to you by Terry Gorry of businessandlegal.ie. Unfair dismissal, or indeed constructive dismissal, are areas of law which can cause employers great problems and quite a lot of money as well. There are two basic principles in relation to unfair dismissals, and these are set out in the Unfair Dismissals Act of 1993 and preceding acts. Firstly, the employer must have substantial grounds for dismissing an employee, and if the employer does dismiss an employee, then he must apply fair procedures. A dismissal on certain grounds is deemed to be automatically unfair. For example, on religious or political grounds, for trade union membership, on the grounds of race, colour or sex, on the grounds of age or pregnancy. These dismissals are unfair dismissals by dint of law, as it were. Also, any employee who is involved in a legal action against an employer, if he or she is dismissed, it's also an unfair dismissal. If you're a member of the travelling community, or if you're an employee taking part in an industrial action and you're dismissed as a result of that, then it's an unfair dismissal. If you're not in the preceding categories and you do qualify to bring a claim for unfair dismissal, regardless, the burden of proof then shifts to the employer. The employer then must show that the dismissal was fair. In order to bring a claim for an unfair dismissal, there is a fairly low threshold. Firstly, you must have been in continuous employment for at least 52 weeks, 1 year. And secondly, you must not be in one of the excluded categories, that is, a member of the Defence Forces, a FOSS trainee, a Garda, or a civil servant. They are excluded from bringing claims for unfair dismissal. Constructive dismissal then is a slightly different animal. It occurs where the employee resigns as a result of the employer's conduct towards the employee. So the employer doesn't dismiss the employee. The employee says, look, I'm out of here. But there may well be a case then for constructive dismissal if the reason for the resignation or the walkout, or whatever you like to call it, is as a result of the employer's conduct towards the employee. Employees on probation then are excluded from bringing dismissal claims. The employer's defence then, well, he must be able to, as I've said already, show that he used fair procedure. Redundancy then also can be a defence, but a false or sham redundancy is not a defence, so the employer must be able to show that the employee was fairly chosen for redundancy. For more information about employment law issues in Ireland, you can visit my website, businessandlegal.ie, or if you have any queries, you can email me at info@businessandlegal.ie. Thank you.